So that's what I'm starting right now. Okay, thank you very much, all of you, for joining this fourth webinar. Today, it's on the challenges that we see or have seen past a couple of weeks, and I think are also still laying ahead of us regarding AI and data protection law during this current COVID-19 crisis. And I'm very happy that our leading researchers within the LSTS research group of the Vrije Universiteit Brussel could join us today to give their insights on this particular topic. We are going to have a presentation by Professor Gloria González Fuster first, then followed by a presentation by Professor Mireille Hildebrandt, and we are going to listen to them just in a minute. I want to just let you know that the VUB AI Experience Centre is just recently started about a little over half a year ago, and as a hub location within the Vrije Universiteit Brussel, where we actually want to gather the expertise, multidisciplinary expertise of on AI research that exists within the university context, and actually to bring together two workshops, two lifelong learning programs, two roundtables, but also thanks to a lot of demonstrators and prototypes on AI applications to create an environment where we actually could meet with industry experts, with policymakers, but also with fellow researchers to have a continuous debate and exploration of the opportunities and threats of AI research. And that's actually the role of the AI Experience Centre. And of course, in these times, we think it is very much our role to be present in the debate. And of course, we now don't have a physical location, so we like to do it now virtually, thanks to this webinar series. Now, in the previous webinar series, there was already some constant or to maybe a red thread to be disclosed or to be seen, and that there is a lot of debate or discussions or sometimes problems or challenges being discovered by some of our fellow researchers when they were looking to solutions, technology-driven solutions, AI and data-driven solutions, when it comes to looking for answers on needs in medical area or in other application areas when it comes to fighting this crisis. So I think this debate on AI and data protection law is actually a webinar that maybe will sum up and summarize or give it at least a framework on where to look for the near future and the long-term future in creating maybe a framework, regulatory framework that will allow in potential future outbreaks to have better solutions, other solutions. Well, let's hope that we don't need them, but I think that there are lessons to be learned from what happened the past 10 weeks for the benefit of all. So I would like to hand over the floor or the mic to Gloria to give us a first insight from her book.
Thank you very much. I hope you can hear me, and now I will try to share my screen, my slides. So probably you will not see me anymore, but that's fine. So yes, I hope you see the slides. Maybe you even see me. Welcome everybody, and thank you for Hans for organizing this. Thank you to all the participants for being here. I hope we can have some sort of discussion in an interactive way. About this, about the title of today is AI and Data Protection Law and the COVID-19 crisis. And indeed, I think much of the discussion could be about this question of the regulatory framework for AI. And this is not a discussion that we are having now because of COVID-19. I think it's important that we remember this, that this is a discussion, is the discussion of the year, the discussion that we were having before the COVID-19 crisis. Actually, the last time we met physically with Hans, we were discussing this white paper of the European Commission, this idea that the European Union needs to have a strategy, a policy, maybe a regulatory framework for AI. And then there's the question about what's the link between that discussion and data protection law, because that's one of the legal frameworks that we have on data protection law. So this is where we were before in normal life. And Then we have this big issue, big thing happening with COVID-19. I think you know what this is about, so I will not try to summarize. I think you participants know what artificial intelligence is about, so you also know. And this is where I do something strange with my thing, that it disappears. But I hope you still can see. Can you still see the slides?
Yes, it's okay.
Okay. Yes, I don't know. They disappear for me, but is there for you?
Yeah, it's perfect.
Okay, so we were discussing the regulatory framework for AI in relation to data protection law, and then this thing happened, COVID-19, and we really very quickly, I think quite quickly, we saw that this was very important for data protection law. So indeed, it has been mentioned, there are many ideas now on how to fight the virus, how to solve the crisis. There are many ideas that involve somehow data, and they have implications for privacy for data protection law. So already by mid-March, we launched this web page trying to just put together all the information that we were seeing about solutions that had implications for data protection law, but also about responses from the data protection law community, from the data protection law authorities, everything that was happening. So then we started doing this in March. And we have been doing this regularly, and we are now quite lucky that we have actually the support also from VUB to keep doing this for a while, because it doesn't stop. So every single day, I would say every single hour, every time I connect to Twitter, there is something happening, something about a new app, somebody saying something about another app, somebody having an idea and somebody reacting. So the good news for you is that we have this website, and you have here the link. You can check it. You can see the project is called Data-Driven Approaches to COVID-19 and Data Protection Law. And we map references, things that happen basically in relation to many themes, but we do focus relatively on the European Union level discussions on the subject of the apps, and probably we'll discuss this later. And then also it's very interesting for us, the relation between COVID-19 and scientific research. So how to do scientific research in a way that it's compliant with privacy law, with data protection law, that it's very important, and perhaps we can discuss this later. But this is online, and if you have ideas on how to improve this to make it useful for you also, please contact us. There's an email address on the website. And this is just to tell you that actually it's not only us who are tracking developments, because there are so many things that actually we are now tracking those who track the developments of things happening. So it's a global conversation about the role of data and the role of AI in this particular crisis. So that's the context. But we all look at this, or we mostly look at this from the perspective of data protection law. And as I said, I think you are experts, you are knowledgeable about artificial intelligence, you all know about COVID-19, and just to make sure that we are in the same line, I thought it was still necessary to say a few words about data protection law, just in case somebody is not familiar with data protection law, to clarify what this is about. And maybe you know what this is about, but still I will take the opportunity to explain this, because it's very important for me that this is clear to everybody. So data protection law, it's about data, but it's not just about protecting data from something that could happen to data. It is basically about these three notions that I like to represent in a triangle. So there are some obligations that are imposed on those who process data. They can process data if they comply with those obligations. When they process data subjects, so that the individuals have some rights, and then we also need some data protection authorities that monitor that this happens. Very, very briefly, what are these obligations of data controllers? There are many, but it's about lawfulness, fairness, transparency. They need to have a purpose. They need not to process more data than necessary, process accurate data, process data only for the time that it's necessary, respect some security obligations, and be accountable. All these principles cover many, many, many obligations specifically. We cannot really go into this, but just to remember that there are some obligations that are there, part of data protection law. And then part of data protection law is also that we have some monitoring by data protection authorities who have to really make sure that these obligations are complied with. And then an important dimension of the whole scheme is that actually people are given rights. They are given some rights, not just because it's nice that they have rights, but really to enable some control over the data that it's with some control of the processing that is going on. So they have to be informed, they have to be told about what is happening, they have a right to check which data are being collected, why is this data being collected, for which purpose, and all of this. So there are many rights. And again, I cannot really go into the details, but basically just remember here, you have this right to be informed, the right of access to data. And then we have an interesting series of rights that might be rights or not rights. So that's a controversy that we have. And that's very relevant for our discussion today. And these are the rights that relate to what we call automated individual decision making. So this is partially about profiling. This is very much about what we broadly call artificial intelligence. And that's one of the most debated issues in this reflection that we are having, even that we were having before COVID-19, on what's the relation between AI and data protection law. And this is really where I was trying to get to situate this debate. This is the question. So we have artificial intelligence. It's there. We are even encouraged to support artificial intelligence solutions. And then here, I hope you agree that this picture represents artificial intelligence. It is supposed to do this. And then the question is, how does this relate to the existing legal framework, the safeguards that we have now in law, including in European law, to protect individuals and their freedom? And many times this discussion is seen as a sort of a reflection about whether the Gdpr is enough to protect us from the threats of artificial intelligence. And you have here the Gdpr. I hope you know a little bit about the Gdpr. That's really probably indeed the main instrument of European data protection law, the General Data Protection Regulation. It's there. And I think it's good if you know about the Gdpr, and it's good that we talk about the Gdpr. But I think that it's something that we should not forget, especially when we think about this debate about AI and data protection law, is that the Gdpr is not the only instrument that we have in data protection law. We have also a directive that applies, for instance, when data are processed for law enforcement, for police purposes. We have a regulation that applies when it's EU agencies that process the data. We have a directive that applies to telecommunications data. We have Eurojust data protection rules, Europol data protection rules, and we have many, many rules that apply in different ways to what happens to data, also when these data are involve some type of profiling or automated processing. So I think that's important when we think about the legal framework that we have. We have actually in Europe a complex legal framework. There is the Gdpr, but the Gdpr does not always apply. When the Gdpr applies, even we have to also move at national level, and different rules might apply. So actually the conversation is a bit more complex than just saying that do we have enough for the Gdpr? It's not only about the Gdpr. That was the general introduction to what is the subject, and I'm finally getting to this issue. So we had this discussion, and then the COVID-19 outbreak came, and I suppose you know what happened. As I was saying, there were many ideas, many solutions, a lot of people being creative in a good way, and sometimes in a strange way, in the sense that it's good, I think, if you're creative with having ideas for solutions, but in many cases it was more like the marketing that was creative. So people who had previously some idea that was perhaps not that useful as such, they repurpose their own idea for this COVID-19 outbreak, and we see this quite a lot. And it raises interesting questions about what's really the function of those technologies. So that's only an example of this Spot, the robot that was walking around in a park to make sure that people respected the rules of social distancing. There are many examples, and I will try to briefly touch upon some of these examples so you see what I'm talking about. And the question is not only just, so the purpose is not only to give you some examples, but really to think about some of the implications of what can we learn from this about data protection law, knowing that we knew before that data protection law is not perfect, but knowing that we also knew that data protection law is very important, and that it's very important that we have the safeguards in place precisely for this kind of moments where people get a bit too creative or get creative, and perhaps we have to accompany their creativity in a meaningful way. So just a couple of examples. This is one. This is about Liechtenstein, a beautiful country probably, and there was this information in the news that they were just distributing some bracelets in Liechtenstein to track the spread of COVID-19. And you have here this bracelet, which looks interesting. And this bracelet, actually, what it does is not a contact tracing bracelet. It's about monitoring temperatures. So to see if you have fever. And what was interesting for me was to see that actually this bracelet was originally, it is presented as being a medical device, but it actually was originally a medical device developed for completely unrelated purposes, which is basically for fertility tracking and conception. So you have this device that indeed does something, collects some data, and now you have a repurposing of this technology for potentially COVID-19. And does it matter? Does it matter that we're using all the ideas, all technologies, unrelated technologies for COVID-19 purposes? I think it does, because if you think about the design of this, it is there tracking your temperature while you sleep. Is this that useful for COVID-19 tracking? Probably, I think it isn't. But I think we have to ask questions when we see these kind of things. There are many types of bracelets, and that's just another one to tell you that it really many of these technologies come from other things. This is happening in Belgium, not in Liechtenstein. This is being tested for COVID-19 purposes in Antwerp. And this is a bracelet that makes noises and vibrates, I think, when you are too close to somebody else. And this bracelet originally was developed for safety of the workers. So it's really targeting the workers that are there. And this raises special data protection issues because, of course, the relation between an employer and an employee is a special relation also legally. So it is worthwhile looking at what those bracelets do. And this is where it gets interesting from a data protection perspective, because this is from the website of this company producing those devices. And then you see many interesting claims about actually whether data protection law even applies. I think that's very interesting, because some of these claims are debatable, but I think that the most funny part is really when they are conflicting. So you have different messages about whether these technologies collect or do not collect personal data. Here, just if you can read this quickly, it says no personal data is collected by these devices, and then it just after this it says any personal information is fully encrypted. So how can you say at the same time you're not collecting data, but the data that are collected are encrypted? I think there is something to think about. We have a similar discussion about whether we are collecting data and whether data protection law would apply in relation to temperature that is being taken when people, for instance, want to enter a place. And some people say, well, it's not necessarily because you are taking the temperature of somebody when they want to enter a building that data protection law would apply. We can think of cases where actually there will be no automated processing of data or structured processing of data that data protection law would not apply. And I think indeed we can think about those cases, but those are not the typical cases that we will encounter. I think that in most of the cases, there will be processing of personal data, and there will be actually the need to think about privacy protection and disregard all claims that this is not processing of personal data. This is just something that it's on the internet that you can buy if you want to. And this is something that I think maybe you can also buy, but it's also being sold. That includes some detection of temperature measurement, automated measurement of temperature. That it's been a similar technology is being used already in Europe. So I think it's tricky that we try to buy the arguments that this is not about processing of personal data, because probably it will be. This is just another reflection about the anonymity of these technologies, and this is a picture with we don't know who, but I think we can recognize somebody looking at some of these surveillance technologies for COVID. Another example that I would like to very briefly discuss is this one. This is a French company, a French startup, because that's more where the creativity is, of course, and they are using artificial intelligence to actually detect when people are in a public space, whether people are wearing masks. So they say we can count how many people do this, and we just do it in a statistical way. And then again, it's interesting because they do very, very bold claims in relation to personal data and data processing. They say we are 100% Gdpr compliant because we don't process personal data. Now, when you read what they do, you realize that, of course, they process personal data, but then they say, we do it so quickly that actually it doesn't really matter. And it doesn't really matter because we don't keep this data. And of course, it matters from a legal perspective that they recognize that they process personal data because of, remember, my triangle, only if we agree that data protection law applies, then rights that are given to data subjects. And here, one of these basic rights that data subjects may have, depending on how this is deployed, is the right to object to the processing. So normally you have, when somebody is processing data, they can have different legal grounds, but if they claim they are doing this on the basis of the legitimate interest, you have a right to object. You have a right to say no. And here they took it very literally, and they said, well, actually, we will put these cameras in Paris, in the metro stations, and if people disagree and they don't want to be filmed, they just have to say no with their head, and the technology will not record the image. I think this is strange as an approach, and they have these images on their website about this woman. I don't know if she's saying no. She doesn't look convinced to me, but still she is being filmed. And the question is, of course, one of the questions here is, if you can say no, then maybe you want to check if the technology actually understood that you said no, but they will not let you do this because they say, because we are not really collecting data, we are really deleting this very quickly, we will not give you right to access this to actually see if you're collecting data or not. So many tricky issues been happening here, strange things happening with interpretations of data protection law. This is just for the fun. This is the theme of this startup. And this is, of course, not about specifically any company. There are many companies doing this kind of developing this kind of technologies. And I think we really have to think about whether they comply with data protection law, but also about how they, when they pretend they do, how they do this. And in the one about the masks, they do say, I think somebody, I might be talking too much. I will finish soon. So in this case, we see here cases of artificial intelligence where they say we are not using facial recognition because we don't recognize anybody because everybody is anonymous. And I think that makes sense sometimes, but might not make sense in the future. So we have to be careful. And I really will conclude in a couple of minutes, just coming back to this idea. So we have AI, data protection law in general, and this question, do we have rules that are clear enough, that are strong enough to protect us from AI? I think in many cases we do. So the Gdpr could give us some useful answers to the cases that I have discussed, but at the same time, in some cases, we don't really have now at the level of the European Union a strong enough framework. And one of the cases in the situations where we don't really have so many safeguards, it relates to the processing of data in relation to borders. And I just want to briefly mention this example that I think it's quite interesting. This refers to the European Travel Information Authorization System, that it's a system of border management that it's already approved at the level of the European Union. It's been developed now, and it's a system that allows for people to get an authorization to travel to the European Union before they travel. And all this is based basically on profiling of people. So you apply, when you give your data is compared with some risk indicators, and then you receive or not this authorization. Now this authorization, it's about security. So the question is whether you belong to a group of people who have been identified as being a security risk, but it's also about health. And so if the system identifies you as being part of a group of people who are have more risk in relation to health, the computer can also say, no, thank you, you're not authorized to travel. The rules are very complex, and I think they are very opaque. And in this case, does the GDPR apply? Well, it depends on who is applying this. So just to tell you that final message, all this is not just there because of the COVID-19. All these technologies, of course, have been developed for years. And this is why before the COVID-19 crisis, we were already saying that we have to really think in advance before any crisis complicates things. And I think I really went, my time is finished, but I lost the images. So I will blame technology for this.
That's okay, Gloria. I think, no, you're perfectly within time. So I think this is a good moment to hand the floor to Mireille as well. And just a reminder, I also dropped it in the chat. So if people have questions, you can drop them in the chat environment, and I will address them to both presenters after the presentation of Mireille. So Mireille, please, the floor is yours.
Yeah, I think that Gloria is still sharing her screen, so I'm not allowed technology-wise.
Yeah, now it is free. You're free to go.
Yes. Here comes. Yeah. Okay, so I'm focusing the presentation on data protection and on data-driven solutions, solutions between inverted commas, because one of the big questions is, what are really solutions here? And to go back to what Gloria just said, where does marketing and then solutions start? I'm purposely avoiding the term AI because I think a lot of the data-driven solutions that are on the forefront in terms of data protection law are not at all what most people would call AI, but basically data-driven. So here we have the mask. We all know that wearing a mask, according to many experts, but certainly not all, is going to save us. And I think all experts agree that washing your hands will always be a big contribution. But by now we have other types of solutions. I want to focus on some of the apps under the heading of issues. Then I want to look at what data protection actually aims to protect. Many people think that's all about privacy. I think when you read the Gdpr, it's much more than privacy. As many people know, the term privacy does not occur in the Gdpr. I want to briefly emphasize that, of course, the Gdpr has rules what to do in a case of emergency. And then I want to go to the interesting issue, the most interesting issue here in my presentation, and that is what happens if you try to hardwire protection solutions into mobile infrastructure. So there is this emphasis on privacy. I thought I would at least put one Dutch joke in. And I want to also begin with part of a thread, just one tweet from Julie Cohen. There erupted this morning, our time, maybe it was midday in the United States on the other side of the Atlantic, a discussion about the last point that I want to discuss. So what is the role of public health surveillance authority, and what is the role of big tech that has its hands on and actually has supported and provided our mobile infrastructure? How do these two relate to each other? So here Julie Cohen says, public health surveillance authority is a long-standing, globally acknowledged exception to the ordinary operation of privacy and data protection laws if there is an emergency. And it never depends on voluntary self-reporting of contacts by a subset of the population. So basically she's saying that it is ridiculous to say that if there is a public health emergency, to make the data that you get to contain and to fight the public health threat dependent on whoever is willing to share their data. She's basically saying that is misrepresenting what data protection law is about. Let's first look at the type of apps that we're talking about. Everybody has been talking in Europe for quite some time now on the tracking contacts apps, but of course there were before that, there still are and all the time new appear that, for instance, try to track the health of people that are infected. That means that you're trying to self-report your symptoms, the nature and the course of your disease to your GP, to specialists, and that this is a two-way thing. So you also get advice based on the information that you share. The tracking apps basically aim to direct people to self-isolate. So you get an alert, and that alert refers to that you were in proximity to somebody, and that somebody you might not even know, and at that point, you also didn't know that they were infected. So if you compare that to manual tracking, which is again, manual contact tracing situations, which have existed for a very long time and have been known to be effective in these kind of crises, this is something extra because you don't always know the people that you have been close with, and certainly you didn't know whether they were infected. It is quite obvious that the fact that you were in close proximity to such people doesn't necessarily mean that you're now infected. It doesn't mean that you need to self-isolate. And the advice that you get is a mechanical advice. It's not a person that is advising you, and it's based on a risk assessment, all based on data and a lot of uncertainties and dependencies. Then we have mobility tracking apps that collect location data, especially on infected persons. This sort of data is used to model the spread of the virus, maybe to do some predictions. So here we see some, what is usually called AI coming in. And we have apps that track immunity, that actually do not track, but demonstrate immunity. So that means if you have evidence that you have antibodies against the virus, you can download that evidence into your app. And it might, for instance, be used to give you access to buildings, public transport, schools, whatever. But of course, it can also be used to prohibit such things. Now, the first question that comes up here, and that should come up, also from a data protection perspective, is, and of course from a public health perspective, is the question whether this application is at all effective, whether it's fit for purpose. And that depends on so many things. We all know the stories about false positives, false negatives, such apps being put out at a stage that is too early, meaning there are going to be too many false positives and false negatives, and people will lose trust and not use it anymore. And the same goes for many of the other creative ideas. Please let's not put them either on the market or put them out as a public health authority if they are not yet ready, if the data is not yet there. From a data protection perspective, if such processing of personal data has the potential to infringe our fundamental rights, then we say that such applications, such measures must be necessary in the sense of proportional to what is at stake in terms of health risks, compared to the kind of infringement that takes place. So this first question is not just a question from the health perspective, but also from data protection perspective. I want to very briefly say something about the fact that many people think that the GDPR is about privacy. As I said in the beginning, the term privacy does not occur in the GDPR. It's in some footnotes that refer to other directives or regulations, but it's very clearly meant to protect the fundamental rights and freedoms of natural persons, not businesses, not governments. Natural individual persons. Of course, in particular, their right to the protection of personal data. But when you look at the GDPR, basically, the right to the protection of personal data is not because we love personal data and we want to protect them against others, but because we love individual persons and we want to protect them. You see that also in two very important obligations in the GDPR. There is the obligation to, when you design a system, when you deploy it, when you tweak it, to make sure that at the level of the design, of the engineering of the system, that you take care of data protection by default. That basically means you do data minimization, data that you're not necessary, you're not going to process. And by design, that means that the entire architecture is done in a way that is most protective. Here you see that when thinking of when such data protection by design and default is necessary, you have to look at the risks of various likelihood and severity for rights and freedoms of natural persons. Not a word about privacy, though of course that's one of the important rights and freedoms. The same goes for the data protection impact assessment. If there's a high risk to such rights, then there is an obligation, a legal obligation, to do such an impact assessment. You could say that that's a translation of the principle of precaution. So do a little research, and if the risks are high, not a little research, but solid research, and the two articles are connected. If you see that there is this high risk, you have to mitigate it. And one of the ways to mitigate it is by doing data protection by default and design. And we're talking about, of course, the right to privacy, but also non-discrimination. And you can imagine that all these sort of applications will start discriminating. In the neutral sense of the term, they're going to make distinctions between people. And sometimes these distinctions are based on prohibited grounds, ethnicity, and other grounds that we think are not a good cause for discriminating between people. So you have to be aware of that. When does this happen? At which point does that actually infringe the right to non-discrimination? Same goes to freedom of speech. Think of chilling effects of the use of these applications. Of course, the freedom of movement is at stake very often. But you can also think of the fundamental right to privacy, and you can think of the whole constellation of patents. Does the GDPR take an absolutist perspective on privacy or data protection? No, of course not. The GDPR is quite nuanced, and it's very much focused also on the general interest. To make sure that, for instance, public health as a general interest is safeguarded. And under certain conditions, it may be necessary to restrict some of the rights and obligations part of the GDPR. There are some conditions for that. Most important are that such restrictions have to be based on a legislative measure. They can't be done ad hoc just like that. Here you see which rights, let's not go into that now, can be restricted. But of course you can't restrict everything, and basically Article 23 says if the essence of a fundamental right would be completely disrespected, then that is not allowed, also not in times of emergency. Now let's look more focused at something that has come up. When people started working on the Contact Tracing Act, which has attracted a lot of attention. So this is about digital contact tracking, like I said in the beginning. Originally, the idea would be to work with location data, to work, for instance, with GPS data. But this was found to be very inaccurate, so very ineffective. So everybody moved towards Bluetooth because it was somewhat more accurate. And then the big discussion started about whether this should be centralized or decentralized. And this means who has access to the data? Is the data about which persons you have contacted? So proximity. Basically, this is still about collecting a kind of social graph about you. It's also mobility data, depending on whether you can link the data with other data. So it can go quite far. Now, who will have access to all those different data? Is it going to be the government? Is it going to be public health authority? Is it going to be the app developer? Is it going to be the operating system, your browser, or whatever? This was a big discussion, and a group of researchers throughout Europe, well known for their cryptographic expertise and their work in privacy and security, decided to build a so-called decentralized app. it's important to realize that what is decentralized is people that are not qualified as infected, because also in that app, those who are infected are not part of the decentralization. They are the people who are known to the public health authority as being infected, and you need that information also to warn others. So in principle, this is about applications that are going to be either mandatory or not mandatory, but they're usually, as we see around the world, this is not just about Europe, offered by public health authorities, independent public health authorities, or by governments. Now, what happened is that at some point, two companies, Google and Apple, who basically have the entire market for mobile phones worldwide, said that they were going to help to decentralize the data and the applications, basically by creating an API that is sort of the interface between the operating system and the app, based on the API, which they said they will later sync into the operating system. That means that you absolutely have no choice. The government has no choice. Other companies have no choice, but also me as the holder of a mobile phone has no choice. Then to accept that this software at the level of the API or the iOS makes certain restrictions. And basically, Gdpr said, we're going to restrict access to the data on the person who's walking around with the phone with that app on the Bluetooth contact tracking data. Nobody will be able to access those data. Technically, it will not be possible. The first thing is to realize that this type of applications and some of the other applications are basically crowd control tools. And these types of tools have been around for quite some time. They're used when a lot of people are together, for instance, in football matches or places like Disneyland. They are used to influence movements of crowd. What you're trying to do is to influence the behavior of individual people based on knowledge that you have that they do not have. This also means that these types of tools can be repurposed for other types of crowd control that have nothing to do with public health threats. This is just one page of the information that, this is from Apple's side, that Apple and Google have provided. Here you can see that the alert that you would get is not like, oh, you're probably infected, you have to self-isolate. No, it's a calculation based on incoming data. This is from a couple of weeks ago now, I think, and I think this calculation will change once we have more data. But it's a risk assessment, which raises many questions like, what if your risk is 4? Should you self-isolate, yes or no? Should you call your doctor, yes or no? Because this is a completely mechanical situation, it's very difficult to ask questions via the app. It's an automated system. Of course, you can call your doctor. What I want to get to is the following issue. So the API of Gdpr restricts access to contact data. That means that governments cannot access them. Now, clearly, this may prevent authoritarian governments from violating human rights. That's how Gdpr is selling this. But it also means that public health authorities are prevented from accessing data that may be relevant to them to work in the public interest for public health. And it's very interesting that in the past weeks and even this morning, a very specific discussion erupted where Helen Nissenbaum, and it disrupted partly on the other side of the Atlantic, where Helen Nissenbaum said, but what if these data are needed for public interest? How come we then say that it is up to big tech companies to decide about that, where our own legislature, let's assume it's a democratic legislature, has nothing to say about this anymore? Others say, well, this whole contact tracing app is based on the fact that you need data on the infected people, because that's where the centralization sits. But from work by both virologists and mathematicians, it turns out that this shouldn't just be about the super spreaders that everybody talks about, but about super susceptibles, and that measures taken at that level might be more important and save more lives. Now, whether that's true or not, there's a lot of scientific evidence there, is not my point. The point is that it seems that the companies that are running our mobile global infrastructure seem to have made that decision in such a way that our governments cannot make other decisions anymore, or without a lot of pain. The last person who made some very interesting remarks is Stefan Engberg, who said, look, the contact data that are on your mobile device that nobody can access can of course be accessed by Apple and Google. So they have now created the most major monopoly you can ever imagine. Because long after this crisis, let's hope it subsides at some point, they will be able to sell access to this type of data, both to commercial and to government institutions. So he said this is something for the commissioner in terms of antitrust law. Just some examples of the tweets, and then I'm going to close. So here, a couple of days ago, Helen Nissenbaum raising this question, constraints placed by an operating system can interfere with health authorities' bid to serve public health and not devolve to individual choice and benefit. And this issue, I think, is important to be on the agenda. And Julie Cohen, somewhere this morning, made an entire thread. This is the same one I showed in the morning. Basically, she's saying privacy protection in public health surveillance comes from concepts like data minimization and purpose limitation. So how are you processing the data that are necessary, for which there are exceptions? How are you actually processing them? Are you doing that based on the right principles? And then she said that are so familiar with European systems that they don't need to be explained. I believe that's quite optimistic, but it's nice. Then she says, which is why France didn't need to explain its legal system to big tech or a bunch of Americans who don't get their own house in order, and why Helen Nissenbaum prefers a system of public health authority constrained by law to a system of big tech noblesse oblige. I'm not taking sides at this moment here because I think that the kind of protection that GAPL offers at this moment might be necessary because of the fact that many governments may be interested in deploying this kind of data grab and in repurposing that sort of stuff. So I'm not entirely in agreement, but I think the following question is the question that we're going to be grappling with, not gappling, but grappling with in the rest of this century. The fact that our democratic and maybe non-democratic legislatures and big tech are now becoming competing legislatures. They are fighting with each other, that have different types of power. We don't have a world government, so these are extremely important and interesting questions, and they're at the heart of data protection law in Europe. What do we want in Europe? And I think I'll close off with that question.
Okay, thank you, Mireille, for that. And I'm looking at the time. I don't want to over exceed 3:05, so I will directly dive into maybe one or two questions that were posted in the chat room. And obviously, of course, the link needs or has to be made with the public consultation that is now ongoing for the European Commission's white paper on AI. Maybe the last 10 weeks and also both your presentations have maybe put things even more to attention, or have maybe sharpened, so to speak, the ideas and advice that needs to be taken into account. And of course, we all know that the Commission wants to make use of the existing regulation that happens or that is in place within the different areas of technology and other application domains to see how that with the challenges on AI, that adaptations or need to be made. Do you think that the examples of applications that you gave, the challenges that especially now are being posed by big tech companies, Mireille, that this urges the European Commission to move fast in making specific adaptations to the existing regulation, or well, what do you think that should be tackled then first?
Well, I think my main advice would be, if I see the white paper and what is said on new types of regulation, which is to a large extent about liability law, that it's very important to get rid of the use of the term AI, because it's a very vague term. There are 1 million explanations, and it would be much more interesting and important to take the articulation of the GDPR in Article 22. So most of the apps that I discussed are not AI, they're very mechanical, but they make automated decisions. They impact lives. They can mean that you have access or not to either buildings or social security or what have you at some point. So I would say that in terms of liability, and what I like about the white paper is that they sort of steer away a bit of the social media stuff, and they talk about physical danger also, where they say it is very important to make sure that we have the right liability regime in place. And then we shouldn't look at whether something is AI or not, but maybe whether it's data-driven and makes automated decisions that actually affect people. So it shouldn't be the same as the GDPR. The GDPR has a default prohibition. I don't think that should be at stake here. But there are, well, let me shut up here because I'm curious about other questions also.
Yeah, there's this question also from, I think, Mr. Kuhn. What do you think of the lack of mandatory stakeholder participation in the preparation of a DPIA and the absence of the mandatory disclosure after drafting the DPIA under Article 35 of the GDPR in the context of these applications? So that's really direct and specific question.
Well, that's of course been a political compromise, and I think it would be very important to have that disclosure in place and to have mandatory discussions with stakeholders, especially with those who will suffer the consequences of certain ways of designing things. But I also see many drawbacks. If you're going to demand disclosure, then there's going to be a lot of money going to window dressing. So I think it's a pity that it didn't get to the regulation, but I can see drawbacks also. And I'm sure that Gloria also has specific ideas about this.
Yes, well, not specifically about this, but I would like to insist on the idea that the GDPR applies sometimes, but it doesn't apply always. And there was a question in the chat about the higher risk. So what about this approach in the white paper that we focus on the high risk processing, and I think maybe it's a good idea, but maybe it's not a good idea, because from data protection law, what we know, indeed we take into account the high risks sometimes, but generally we protect everything, because we know it's too easy to say we only focus on the high risk and then you enable everything else. That's generally not good enough, and especially with the high risk part, is if you imagine, for instance, that everything is permitted, but AI in law enforcement, it's high risk, then you go to the situation where everything that is high risk actually can be very, very easily subject to exceptions, and Mireille mentioned the exceptions. You have high risk rules, so rules for what is high risk, and then you have full exceptions for everything that is high risk. There is a public health emergency, everything is exempted. Security problems, so if we have rules that can be very easily avoided, then it's useless. And in this question of transparency, so normally we say we have an impact assessment, we make it transparent, we make everything transparent. Maybe some things we make transparent, but even now we are not making transparent data protection impact assessments in the security context, because it's secrecy, security, you will never know. So then I think it's a bit a waste of time in a way to insist that we need transparency, except when it will be high risk, there will be no transparency because it will be security or extreme thing that so we really have to think, if we go into the high risk special kind of thinking, that we remember then exceptions will pop up. So we have to find a way where we have rules that apply even when precisely when the temptation to have exceptions is stronger. Yes.
Yeah, and maybe a last question from one of the participants, Claire Barbeau, is considering in a hypothetical case that regulations and directives are protective enough of personal data. Do you think that today's society has the will to know more about those protections, and if companies or institutions or governments are compliant with them? Do you think that individuals have the skills to understand those protections? Do you think today's society knows and are interested in the purpose that aim the collection and processing of data? Do we care? That's actually the basic bottom line. Do we care?
I'm happy to say we care. Of course, we care. That's for sure. But just to make it a bit less about big statements. So I think about this question specifically of Article 22 and automated decision making, it's very interesting, because basically the message in the GDPR is people are not aware. Indeed, people don't know they have rights. People don't know the data are being collected. They don't know the consequences. This is why there are obligations of transparency. So when you do use this kind of AI-related automated decision-making things, you have to disclose the information. But strangely enough, the GDPR does not oblige data controllers to tell people that have rights that apply to these cases. And I think it's one of the big mistakes of the GDPR, that there are some transparency obligations, but not to give full information to data subjects about when this automated decision-making is happening and the rights they have, which explains that now, almost 2 years after the GDPR, nobody's really asking questions about this, because we are not being told. Even if we read the privacy policies, there's nothing about it. So I think much can be done there. The only way, so people care when they know, and they know if they care, they want to know more. It's always a circle. And the GDPR there, it's let's give more information. And I think we have to give more information, indeed, specific about this automated decision making, because the things in the GDPR are not strong enough. But maybe Mireille wants to say. So.
Yeah, so I think that this is about the issue of consent and informed consent. And if we would give people all the information that they need to consent, they would just throw it out like the cookie banners that erupt. I think there are certain obligations for controllers and processors. And if those obligations are followed, then the consent becomes meaningful again. Because there are certain things where you're not allowed to ask consent. Mm-hmm. Because it's not necessary, and if you then still ask it, and for instance mix it up with other consent, people are going to be totally confused. So I think many of these problems, they hinge on the fact that the GDPR is not yet enforced sufficiently, and I think that's normal, and that's a good thing. We're not living under a dictatorship of the GDPR. This has to be tested in practice, so all the data protection authorities have to to get real questions. Companies have to interact. Small and medium-sized companies, I think, in Europe are extremely important. They need to organize themselves at certain sectorial levels to get the right information. And if the obligations for controllers that are in the GDPR are properly, let's not talk about enforcement, but properly applied, then all this stuff about getting consent questions for things for which no consent is required should stop. The cookie problem, the cookie banning problem, in my opinion, is an invention of the marketing industry that said, look, we're going to ask for consent that we don't need and mix it up with consent that we do need. People will get so irritated. And I think that's highly problematic, because it's too easy then to say, oh, people, you know, they're too stupid to do consent. No, consent has to be meaningful.
Yes, I still think that even if GDPR was fully respected, still we will not be in a perfect situation, because the GDPR can still be improved.
Yeah, and I don't think we are ever going to be in an ideal situation, because that's not what law is for. That's, you know, yeah.
Yes, and ideally, a realistically ideal situation.
Even then, this is something we have to do together. We have to get this conversation going between business, between NGOs. People need to be represented. People have to get organized even better than being represented. And there's a lot of work to be done. So people that expect that after 1 year, the GDPR will turn out to be paradise in Europe. I love the way Julie Cohen portrays us, but in Europe, we know this is going to be hard work, how to interpret which level of abstraction is the right one to approach this. And of course, there are very huge economic interests at stake here that we have to take into account, and we should not be naive about that.
But I would indeed then take that also as a final advice, and on a positive note, that only by collaboration in an open and transparent way, and indeed have all the stakeholders around the table to actually build on that solution step by step, I think that will then allow us to be prepared and to maybe make sure that in the potential next outbreak that we can actually move faster with certain technology solutions, but at least always bear in mind that we put the humans and the rights at the forefront of these solutions. So thank you for the presenters to give your insights on this matter, and also for people present this afternoon, this warm and sunny afternoon in Brussels at least. So thank you very much for attending, and hope to see everybody somewhere else in a safer environment, and maybe in real life when possible. Thank you very much, everybody, and talk to you soon in another place. Bye-bye.
Thank you.
Bye.